sir, and good evening.
How are you? I think yesterday the class was good. I hope all the learners have enjoyed the yesterday's session. And today is the second day of that particular course. I request Ms. Usha, please take the session. These recorded videos, as again I am informing you, it already uploaded in our RC Visakhapatnam YouTube channel. The students can utilize the facility and prepare for your examinations. Thank you. Please go ahead, madam. Your mic, please on your mic.
With your permission, sir, I'm continuing with the class.
Yeah, please.
Okay. Good evening, everyone. I hope the yesterday's class may be useful for you. And today, basically, we are going to discuss about the second portion of your course. That is, are the important areas we need to cover today about by focusing on basically your course that we are entirely discuss about today about patent. So, starting with the previous explanation also, the new areas are I'm going to cover today. So, firstly, we would like to discuss about the what is basically patent, its meaning, and and what can be patented and what cannot be patented. Then, what are the other provisions are we available, classifications, and majorly, then we will directly focus majorly we are going to be focused on what is the procedural aspects for filing or obtaining for a patent. Okay, and later on, the later part, we are going to discuss about the international patent search. Then another part we are going to discuss that the patent application and its claims, and after that, how it will be important or using as a commercial purposes or it can be commercialization. Later on, we are going to discuss on the other half that the infringement of patent and what are the remedies are available or penalties will be available or if they are having any grievances or not. After that, what is the procedure for the filing for an opposition or what is filing of opposition? Then what are the grounds are available when the patent cannot be infringed or the other grounds will be available. And the last and most important part we are going to discuss for here, that is the IP appellate board, that is intellectual property appellate boards. What is the board's primary power and function, composition, what is its importance? These are the key areas we are going to discuss in this lecture today. Okay, I hope all of you are ready. So let's begin. So I'm going to discuss about a little bit portion what we are already discussed earlier as well. So basically, patent. Patent, what is patent? So basically, patent is a grant, like a grant for an only specifically to an invention. Okay. So this invention means a new product or a process which involving an inventive state and capable for industrial application. So here we are basically talking about that patent which is grant for an innovation by the government and which is provided to the inventor, okay, who is inventing that particular patent. So in exchange for the full disclosure of that particular innovation. After that, like we can say that a patent is an basically providing to an inventor which providing them an exclusive right. Now here the exclusive right means the only the inventor only can enjoy the right until and unless the exception is always there if the inventor is assigning the rights to somebody else. Okay. So this patent is can it will be providing to the only to the exclusive rights by the law to applicants or the assignee, which like whichever is will be there, or they doesn't exploit their innovation only, and it will be provided for a limited period of time. So the patent holder has the legal right to exclude others also from the commercially exploiting his innovation for this duration of such period. So, in return for exclusive rights, the applicant is obliged to disclose the invention to the public in a manner that enables the others also, which skilled in the art, or it can be replicate the information like invention. The patent system, in this patent system, it is a kind of a design to balance the interest of the applicant and also the assignee, like who having the exclusive rights, and the interest of the society as well. Like by how? By disclosing the innovation. Now, we need to must identify that what can be patented and what cannot be patented, right? So here, what is patented? That is same, which having the the innovation, which having a like new inventive steps will be involved under it. Then only it can be patented. So, like what cannot be patented here? If we look into our the statutes, we have that which regarding in the Indian patent law, that is Patent Act 1970. So, as per this act, Section 3 is being stating there are the basic subjective grounds, which is directly stating that under this subject matter, the patent cannot be provided or granted, because these are exclusive ground for the refusal for any kind of patent application. So for on the very first ground, the patent cannot be provided on any kind of frivolous type of inventions. Another most important ground is the invention if it is contrary to well established the natural law. Means the natural law, whatever the we having the Indian laws are already been existed. So if it is being contrary with that particular law or any particular existed laws, rules, regulation or something, then such innovation cannot be granted or accepted, or patent will be the license will be provided to that particular applicant. After that, if that any subject matter of innovation requiring like any kind of commercial exploitation, or it's having a primary use of inventions, like which is a contrary to the public order or morality, or maybe which causes a serious prejudice to any kind of human health, animal health, plant life, or anyhow it will be affecting to the environment. Okay. After that, it cannot be only being provided only merely only discovery for a scientific principle. Another one, the another ground is that the if any innovation is only for formulation of an abstract theory and which is already being published. Okay, then also that application could not be accepted. Later on, if that particular innovation discovering for a any living thing, like it's not being covered under the subject matter of any innovation. After that, that any kind of discovery of non-living substance occurring in nature, that is also not being acceptable. Um, Mere discovery of any new property or new use for a known substance, or of a mere use of a known process, which like any kind of like machines or apertures, like unless such known process and result in a new product or employ at least one new recurrent, so that on that condition also it not be provided the patent license. Later on, the another ground is substance obtained by merely admixture, resulting only in the aggregation of the properties, like those properties need to be the component thereof, like of a process, any kind of specific like process for producing such substances. Or we can say that the any simply arrangement or rearrangement or maybe duplication of like known devices, which is already being established or innovated by somebody else. So each functioning independently of one and another is non-unknown way, right? Because the idea that the whole conception of invention is already being proposed by somebody else already, so it cannot be only acceptable as a new innovation. After that, the another ground will be there that uh, the any kind of basic method of agriculture or horticulture are also not will be going to be accepted, like any invention which is related to like a specific uh, any process for medical, surgical, curative, then diagnostic, curative, therapeutic, or any other treatment type of human beings, or any similar treatment for animals also, which can they are being claiming to render them like free or like free of the any kind of diseases, or if they are saying that it will be increase their economic value, or the like that will be their products like will be useful for all, like of that if the ground they are stating, still those type of application are will not be entertained by the registered of the patent office, because of the clear straight restriction has been mentioned under this clause. The another ground has stated that if any innovation which is leads to any plants, animals in a whole, or any part thereof under the microorganism, but including the seed varieties or specific essentially biological process for production or any propagation of the plants and animals, then also it will not be provided. But in some circumstances, that organisms like including seed or varieties of seed and species, if it will be there, some of the part it can be acceptable depending upon the innovation, and if they are able to prove the novelty, then only it will be allowed or acceptable. Otherwise, it won't. It's a clear restriction. The another that ground wells there, then any kind of simply mathematical method which could not be acceptable. Okay, as a patent, like nobody are allowed it to get patented on some specific mathematical method. Okay, similarly, any kind of a specific business methods are also cannot be acceptable. Now, any kind of specific algorithms like are being strictly restricted to granting a patent application or the patent license. So here we are talking about algorithms, right? So algorithmic functions is completely comes under a protected under the specifically copyrighted act, not to the patent act. So that's why it's a clear restriction here. Why algorithmic works is comes under copyrighted protection is that the algorithmic task is being the basic the codification. So whatever the coach has been writing by the coder, that will be a literary work. It counts as a literary work. So it will be the subject matter of covering the protection under our Copyright Act only. Okay. So that's why this is not the ground for getting a patent license. It will be a restriction simply. After that, the another most important ground for rejection of patent application is if it is the same as a computer program per se also, that is also come under this algorithmic functions and all only. After that, that the literary work, dramatic, musical, and artistic work, or any other aesthetic type, like aesthetic creation, including like of cinematographic work and television like television productions or anything, whichever will be there. These are not the subject matter of the patent. This is clearly clearly stated by the Patent Act itself. So these are the works like a literary work, dramatic work, musical or artistic work, or any other aesthetic creation, including like of we are stating that cinematographic work or the television productions. Like these all are the subject matter of copyrights protection. Okay. After that, presentation of any kind of information only. So that also the not the subject matter of granting a patent license. Okay. After that, any kind of topography or integrated circuit, these are also not being the part of the subject matter of protection for patent, because regarding any like all the type of layout designs act, we the law we having, if it is met with the subject matter of that particular innovation, that law will be registered under that particular statute, not under our patent act. Okay. The another most important ground for rejection is there, like any innovation which are containing any kind of traditional knowledge, or in or an aggregation or duplication of known properties of traditionally known components. Okay, or such components of components. Now here we are talking about the traditional knowledge, right? Why this traditional knowledge? Because if I give you an example, the traditional knowledge comes with some knowledge which is coming from our ancestors to ancestors, like maybe some procedure for curing a disease. So, which is already known in the prior to our ancestors. So, simply this knowledge has been transferring from one generation to another generation. So, simply right now in current phase, nobody can simply stating that this is the my new innovation that to treating this kind of disease, and I want to get patented for this kind of disease treatment. So, like it is not being provided. So that's why it is the direct restriction, because these traditional knowledges carries to different culture to culture, community to community will be there. So that's why it is our treasure to we need, it's our duty to treasure these traditional knowledges, okay, and utilize it later on, and not to giving in a public domain in such a way that somebody not to provide in personally to somebody else in such a way that anybody can get a monopoly on that particular rights. So this is also the last and most important reason for where this innovate, like any innovation which is at the traditional knowledge or any kind of aggregation of duplication of any known properties or of any like traditionally known components something will not be providing or granting the trademark. So now it is being very much important to understood that uh, um, what is meant by a new thing of innovation, that we are talking about innovation, right? So innovation means a new substance or new something. So this is has been defining one major term, that is called novelty. So what is novelty? The term and the steps and procedure has been defined through our the Supreme Court's proper guidelines and interpretation. We can find it out over there. If we look into the case of Novartis versus Union of India 2013 judgment, you can see the detail about the innovation, the meaning of innovation or new thing or novelty. What is it? The principle has been defined clearly over there. So, if you talked about what is novelty, it is means that we're having a complete uh, like uh, um, new concept has been arrived there. First of all, there should be a new inventive steps, and that inventive steps need to be utilized for the commercial purposes. Then only such innovation will be using as a innovation and grant for the patent, like patent license. Okay. So now we are going to give a brief idea about like uh, like who are will be the beneficiaries for this patent, right? This also we need to know. So we are like simply we can say that the inventor is the basic like firstly the inventor is secure from the from the competition and can like exploit the innovation for his gain, right? But also for the public, for the public's benefit, sometimes the government can also be using such patents. So that is also called that compulsory licensing and all the conceptions will be involved we having. This our law contains all of this. So the like for the public, the innovation becomes public knowledge. And this the like the technology is freely available after expiry of the patent. And it will be the cheaper and better products becomes the available towards the society. Okay. Now, if we are talking about that, what is the patent system in India we having? Like, what are the procedure or the full mechanisms of the patent like system we are being following, the Indian model. So, the patent system in India is basically governed by this Patent Act 1970, which is again amended in the 2005, and also it is being amended additionally the patent rules also, which is stating the proper procedures and all everything. That is the patent rule 2003 we are following, and which is again amended for twice, amended in lastly in 2006. And so we are following that current updated rules. So if we're talking about the how it will be like administration, like how it will be functioning. So, in administration, the patent system in India is like administered under the superintendence of the Controller General of Patent. Like this is also including the designs, trademark, and geographical indication also. So, one particular office, one particular controller handling the other applications as well. Here, so patent, design, trademark, and geographical indication. Okay. And the Office of the Controller General functions under the Department of Industrial Policy and Promotion. So, Ministry of Commerce and Industry is look after the whole control over this office also. Like indirectly, they are getting the report from the controller. So, there are four patent office in India we have. The head office is located at Kolkata, and the other patent offices are located at Delhi, Mumbai, and Chennai. So the controller general, basically delegates his power to the joint controller, and the like one there will be one senior joint controller and one joint controller, and apart from that the deputy controller and assistant controller will be the person will be sitting in that particular offices. Okay. So the examiner of patents in each office discharge their duties according to the direction of the controller. Now, the patent information system at Nagpur has been functioning as a patent information base for the users. So, like this patent information system maintain a comprehensive collection of the patent specification and patent related all the literature like on a worldwide basis, and also it provide the technological information which containing in patent. Okay, or patent related literature through like searches of like services, and which provide also a patent copy supply services to various users of the research and development establishments. Or apart from that, the government officials, private industries, business, then any kind of inventors or the other users, whoever will be searching information, then it will be available towards the users, okay, within the India only. It can be accessed. After that, if we are being summarized the whole administration, so we can say that the hierarchy of the offices of the Indian Patent Office is like that. Controller General of Patent, Design and Trademark and GI will be the highest post. Okay. After that, under him, the other post will be available. That is, there will be one examiners of patent and design. There will be another one is the assistant controller of the patent and design, who is assisting the examination, like examiner of the patent design as well as the controller. Then after that, deputy controller of patent and design will be there, and the another post, joint controller of patent and design will be there, and senior joint controller patent of design will be the post. These are the officials will be sitting of this particular offices. Okay. So, if we talked about the jurisdiction of this patent office in India, we have like any like applicant or like a first mentioned applicant. In cases of like a joint application, they can file the application for patent at the appropriate patent office under their jurisdiction. Like he normally, that applicant, whoever will be, is normally wherever he is reside. Based on that, they can like find it out their domicile places, and they find it out their offices within that particular jurisdiction which is being working, they can file over there. Or they have an option that they like he has a place where the business or the place from where the innovation actually originated. There also an jurisdiction or the option will be available to the applicant, they can file. So, for the for the applicant who is non-resident, like non-resident or having no domicile in India, or neither they having any business conducting within the India, then in such cases, the address for the service in India or the place of business of his like a patent agent, okay, determining the appropriate patent office where the application for the patent can be filed. So, if we are summarize that the offices and the its jurisdictions are how it will be break down the territorial jurisdiction. Firstly, the patent office, which having one branch in Mumbai, right? So this Mumbai branch has been containing the basically the state of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, then Union Territory of Daman and Diu, Dadra and Nagar Haveli. The another patent office branch is Chennai, which is also containing the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the Union Territories of Pondicherry and Lakshadweep as well. So, apart from this, the another patent office branch of New Delhi, which is containing the jurisdiction, the whole territorial jurisdiction, including the state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, then Uttarachal, Delhi, Union Territory of Chandigarh. After that, the fourth and major head office, the main patent office uh, is under the Kolkata. It is the Kolkata office resided under the state of West Bengal. The head office having the rest of the all the parts which is covering under this jurisdiction of Kolkata's office. So now we are going to discuss about the different types of patent applications. Okay. So there will be basically we are going to like we can say that there will be a basically a more or less five kind of applications will be there. Firstly, the ordinary application, which is based on a specific person which is having the original like ordinary work for has been done. They can be simply file that application before their nearest jurisdiction, no complication, nothing will be there, it will be dealt with that. Like it's a simple procedure and simplified that. Then application for patent of like addition. Like this application for patent addition, this type of patent application will be granted for the improvement or modification of the already patented invention. Okay, or for an unexpired term of the main patent. then this kind of application like application for patent of addition can be filed. After that, the another one type of patent application is divisional application. In case of divisional application, it can be filed in case of like plurality of the invention, which is disclosing in the main application. The fourth type of patent application is convention application, which is claiming to priority date on the basis of filing in convention countries. So whoever will be the convincing countries will be there based on the convention, whatever the rights will be there, and if it is the India will be the signatory of this convention, then definitely they will accepting this application regarding based on that which type of application and which date it was filed. Based on that, the priority date will be calculated. So that's why this convention for application is also being acceptable. Later on, another type of patent application is there, that is the national phase application. So here it is the most important here that, and mostly most of the people are using this PCT in that sense that it is a national phase application under the PCT, like Patent Cooperation Treaty. So under this treaty, whoever the signatory countries will be there. So if any applicant is just simply filing one application under one national, it's automatically giving the protection to the another nations as well. For example, A is a person who is trying proposing a particular, like A is a person who having a particular innovation who wants to get protected under India, and A is a domicile of India. So A is bound to get the patent registration under the Indian office definitely. So as the A is not get applied for the another nation to getting a patent protection, so they are not getting, right, generally in general sense. But in case of national phase application, if A is a inventor, if he is filing an application before the patent office by a applying a under a PCT, Patent Cooperation Treaty, then those the conventing countries, for example, if it is there USA, UK, or any other country along with India will be there, it will be giving the equal protection to all the countries. So Mr. A will be getting protection from India, USA, and UK at the same point of time, and Mr. A do not need to face the procedural like face some kind of procedural hurdles to the other countries. One simple application can resolve the all the problems and they can get benefited. Now, if we can say that who can apply for the patent, so it's being very obvious. We can say that in one simple term, any national, foreign national, or any Indian national can be eligible to filing and patent application. Okay, either they can file an alone, or they can file jointly with the another, or they can approach to the any assignee or a patent agent on behalf of them, who will be become the legal representative of any deceased. They can file the application on behalf of the inventor or his assignee, or we can say. So after that, after that, this brief introduction about that who can be filing the patent, what are the types, and this thing. I think now we are going to discuss about mostly the major important part is that is procedure for filing a patent, like how we are going to get a patent. So, this is following basically a brief. The grounds will be available in the majorly 7 stage will be following over there. How where we are filing the patent application. So, the firstly, if we are saying that we need to first file an application for patent, then after that, with one or the other patent offices based on the jurisdiction and the office residing of the applicant or by the agent, we can say, then we need to pay the required fees, application fees and all. Then the information concerning the application and the detail of the fees, like how much need to pay for which type or subject matter of the patent or the classifications of the payments and all. It will be obviously provided towards our the official website of patent office. The government of India is already prescribed. For time to time, it will be changing. So you can follow over there for the updates. And after that, we need to follow the guidelines for applicants, like also available on the website only. So what need to follow? Guidelines including the conduct of search, like prior search we need to do, like whether there will be already published any article, like innovation or not, whatever the application or the subject matter you are going to propose. And also the after that later on this application going to be published for a certain time, then the conduct in depth examination, and if they're having any raised objection regarding the application they can say it, or if there is not any objection then directly the grant for the patent license will be done. So this is a brief 1 or 2 lines. Now we are going to discuss about in detail. So, for being as an applicant, what are the general precautions are they need to be obtained, like by the applicant, right? So the first, firstly, if we say that they need to file the system, uh, like uh, like the applicant first need to follow up the system which is employed or prevailing in the Indian structure. So, in which among the person having filed the same innovation, okay, they need to find it out. So first, one is granted a patent. Thereafter, first one is a grant a patent. Therefore, a patent application should be filed promptly after convincing the innovation. Then it is a common experience that through the ignorance of the patent law, maybe the inventor act unknowingly or jeopardize the chances of obtaining patent for their innovation. So, to just to get rid of it, we need to do the prior search. Then the most common of this like indiscretion is to publish their innovation in the newspaper or scientific or any technical journal, like before they are applying for the patent. So in such circumstances, publication of an innovation, even by the inventor himself, would like except under certain rare circumstances, which constitute a bar for the subsequent patenting of it. So similarly, the use of the invention in the public or the commercial use of the innovation needs to be the prior to the date of the filing for the patent application is necessary, which a fatal objection to the grant of the patent for such such invention, where this is thereafter it is being important to say that however, no objection to the secret working of the innovation or by way of reasonable trial or experiment, or we can say to the disclosure of any invention to the others is confidentially has been done. But still, the applicants need to be filed the application like priorly whatever the idea they are being thought of and need to be at least reach out to the office about their submitting their application first, then they can go for any other they can attend any convention sorry that conference or any other presentation about or they want to promoting for their patent or something they can do. So until and unless they will get protected but like legally protected under the Indian law, they should not be represented to the other place. So, so the another mistake we can see, like say that which the usually the applicants are being did that which is frequently made by the inventors that is to wait until their invention are fully developed for commercial work before applying for patents. Okay, so it is therefore advisable to all the applicant who are apply for a patent as soon as the inventor's idea of the nature of the invention, which has taken a definite shape. So it is like it is permissible to file an application for an patent which is accompanied by the provisional specification, like which describing the specific innovation. Now, the application may therefore be made even before the full details of the working of the invention which are developed, only allowed. The filing of an application for an patent disclose the invention which secure the priority date of the invention and thereby enables the inventor to work out the practical details of the invention and which to be filed with the specification, detailed specification within the 12 months of the date of filing for the provisional specification. Like now, like if we now say that like before filing, that what are the major steps they need to be find it out, like any applicant need to be find it out, and they need to be specifically clearly mentioned with their patent application. Okay, they need to be drafted with a techno-legal language about their whole innovation. Okay, they need to be specify about the new product or process in which whatever the area they are seeking for the protection, like involving an inventive step. And also they need to be clearly stated in that application about how it will be capable of being made, okay, for use for the commercial purposes, or it will be benefited for the industry. And it means the innovation to be patentable should be technical in nature, right? So it should meet the following criteria. So the criteria need to be followed first. Basically, we are finding out these three principles need to be made that particular application. First, the principle of novelty. That talks about the matter disclosure of the specification is not published in India or anywhere before the date of the filing of the patent application in India. The another principle is the inventive steps. Here, the applicant need to be satisfied that the application is not obvious to a person, not obvious to a person which is skilled in the art or in the light of the prior publication or knowledge or document. Okay, so it should be completely new or the new idea they are proposing, then only it will be protected. So make sure that the applicant need to be drafted this clause clearly. After that, the another most important principle for the patentable innovation that are being checked out by the office, that is the third principle is industrial application. So all the innovation, whatever the applicant is trying to propose, that should possess the utility. Which utility is requiring that so that it can be made or used in any industrial benefited purposes. Okay. So now, if we are said that appropriate, what are the appropriate offices for filing an application, like for like other proceedings, right? So, application is required to be filled according to the territorial limits, which are applicant for the first mention. Like the detail mention will be clearly stated out there. So mentioning the applicant in case of joint applicant or patent, to the like for the patent particularly, normally from where they are being residing, the domicile address and all based on accordingly, or the invention from where the it being originated. So later on, the applicant need to be specify the patent or the party in proceeding having no business place or domicile in India. The appropriate then the appropriate office will be according to the address of the service in India. Like give a, like wherever these services will be provided by the Indian government, the applicant or the party in that particular proceeding. So the appropriate office once decided in respect of any proceedings under the Act shall not ordinarily be changed. So once they are being fixing their jurisdiction, they need to be continue with the same for the rest of the procedures. Now, the after completion of the first step, this is the second steps we are talking about. That is containing the uh, publication and examination of application. Like after successfully completing the patent application, it will and it is being accepted by the patent office. Then after that, this will be the task has been done by the patent office, that those application of patent will be available to the public that application form will be published for next 18 months to the official journal of that patent office, like specific region of that particular patent office. So it the database will be added this information and it will be available for all. So in the meantime, if anybody having any objection, then immediately from the date of the filing to next 18 months, they need to be raise their objection before that patent application, like patent application number, along with they need to write it down about a objection application before the patent office. If beyond of this 18 months any objection raised, it cannot be entertained by the office. But within the time, if it is being there, then the objection should be examined by the registrar of the patent office. That opportunity will be provided to by following the natural justice, to they will be heard by the both of the sides, that whether is it really a violation or not. The procedure is going on. So this publication of the applicant, has been, if it is finded out any, without any objection, then directly the applicant can file for the request for examination. Okay. So if we now this all the application of patent, which is like like all the application for the patent except for the application which is prejudicial to the defense of India, or any abandoned due to non-filing of a complete specification within the 12 months after filing the provincial, or withdrawn that the same within the 15 months of filing the application, are published in the patent office journal just after the 18 months from the date of filing of the application, or the date of priority. Okay, whichever is earlier. Based on that, it will be entertained. And the publication includes the particular of the dates of the application, application number, name, address, along with the abstract. So the applicants can go with the application for patent, which are not open for the public inspection before publication. Okay. So after the date of publication, the application as stated above, the complete specification along with the provisional and drawing, like whatever their intention, if any abstract publication or any form or any like plain paper on any correspondence between the office, the applicant may be inspect at the appropriate office by making a writing request to the controller in the prescribed manner, or to the payment of the entire rest of the prescribed fees, whichever will be applicable, they can go or they can follow accordingly. So after this procedure, if no objection has been raised, or if it is any objection has been raised, then also the registered of the patent office can call for summon to both the parties, the applicant and also the particular the other person who is raising the application. Okay. So after the trial, they only been decided, and if it is the reason, it will be justified to the controller that the applicant's application will not violating any kind of already registered innovation, which is owned by any particular person who is raised the objection, then that grant of patent can be done, or the basically it will be the step which need to be taken by the applicant, that they need to file another application for which is by requesting to the authority for to examining the patent application. So in this stage, the application for patent will not be examined if no request is being made by the applicant. Okay. And For this request for examination also, they need to be need to be pay some prescribed fees, which is around approximately 2,500 to 10,000 again. Okay, for a natural person, or if it is for any other like natural person, respectively, it will be depending upon it. Like for any corporate or like a company or something, it will be depending upon that. Okay. So within a specific period of 48 months from the date of the application of filing. So since that date, they need to be filed for this request for examination. Otherwise, their application of filing that patent application won't be acceptable or continuing. It will be got rejected. So where no request for examination of application for patent has been filed within the such period of time, so the aforesaid application will be treated withdrawn, or thereafter the application cannot be revived also. Now, how this examination will be done? This examination of application for patent, where request has been made, then only the application by other interested person and which will take up for examination. So according to the serial number represent received from by the application along with the application copy, the form number 8 need to be submitted. The first examination report stating the objection requirements is communicated an applicant or his agent according to the address for the service ordinarily within the 6 months from the date of request has been made, and for the publication which is later, it's need to be done within the specific period. If the application become incomplete, or we can say that the if the application the complete specification should be amended, then only it will make the objection required within the 12 months from the date of examination report. So no further extension time will be available in this regard. And if it is all objection are not compiled, then the period of 12 months, the application shall be deemed to have abandoned only. So later on, the withdrawal portion, the schedule timing will be available for the patent application will be there, that the application for the patent can be withdrawn at least 3 months before the first publication, which will be 18 months from the date of filing or the date of priority, whichever is earlier. Then the if they are having any opposition proceedings for to grant of a patent, then where an application for a patent has been published, but a patent has not been granted yet, then then any person who may in writing represent by way of opposition to the controller against the grant of any patent. Okay. And the representation shall be filed at the appropriate office and shall include a statement and evidence. So if any in support of the representation and the request for hearing, uh, based on the desired, it can be done. So if they're having no position, raise a then that of pay will be provided. So when all the requirements are met in cases of opposition, which is mentioned, if you see section 25, subclause 1 of the Indian Patent Act, which is stating a specific ground for oppositions, like ground of taking the valid oppositions for that particular patent obligation. If any kind of the objection if they are raised. So if the opposition is decided in favor of the applicant, then the patent is granted 6 months from the date of the publication under section 11A of this patent, and a letter of patent issue. Entry is basically made in the register of the patent, and it is notified to the patent office journal, patent office journal, and thereafter opening the application, and later on the specification and the other related documents for the public inspection on the payment of the prescribed fee will be done. So this is the basic procedure how the patent can be granted. Now the we need to know that the no like the IPR rights will be granting for a long period of time. Okay, so it's basically providing a specific and short duration of time for a depending upon each different type of IPs. So in case of patent, the patent will be generally providing for 20 years. The term of every patent will be for 20 years from the date of the filing of the patent application. Irrespective of whether it is being filed within the provisional or complete specification or not, it is not mandatory. It will be 20 years only. So the date of the patent is the date on which the application for patent is filed. And the term of the patent in case of international application filed under the Patent Cooperation Treaty designed by India will be also providing for 20 years from the international filing date according under the Patent Cooperation Treaty. So, a patent will have ceased to effect on the expiration of the period which prescribed for the payment of any renewal fee. And if that fee is not paid within the prescribed period, then obviously the inventor is going to lose the license of that particular patent. So now, the procedure for the renewal and restoration of that particular patent is the applicant need to keep like the patent look into the patent licensing force, okay, and for renewal fees and all need to be paid every year, then only it will be continued. So the first renewal fees is payable for the third year, okay, and must be paid before the expiration of the second year. So from the date of the patent, like if the patent has not been granted within 2 years, the renewal fee may be accumulated and paid immediately after the patent is granted. Or they can do that within 3 months of its record of registered of patent, or within extended period of 9 months by paying the extension fee of 6 months. Like that's because of that, the applicant need to submit the form number 4. Okay. So we briefly explain about that that what are the documents required for filing the patent application. So first of all, form number 1, form number 2, form number 3, and form number 5 are most important forms you need to be filed along with the application form. Okay, so the form number 2 contain the provisional and complete specification, and then form number 3 regarding the information and undertaking listing the number, filing date, current status, and all, whether it will be infringe the patent application or in duplicate or not, like that. And patent 5, declaration of the inventorship, where the provisional specification is followed to complete the like specification, or in case of convention, or whether it is a PCT national phase application or not. It is also being need to attach or they need to be filed. Okay. Then there is an important area you need to know about it, that an applicant can request for permission to file in abroad also. So if any application is to be filed in abroad, so without filing in India, so in such circumstances, it should be made by made only after taking a written permission from the controller. So the request for permission for making patent applicable outside India, it shall be made by submitting the form number 25, which is along with the fee near about around 1000 to like 1,000 to 4,000. Like for a natural person or any other, for artificial person, it will be respectively as per vary according to the every years. So a gist of invention should also be filed along with form number 25. Okay. Apart from that, the one more information I think you should aware of it, that is the restoration of lapse patent. Like how you will be restored if your patent application got lapsed, right? So where a patent has ceased to have effect due to failure to pay the renewal fee within the prescribed period, then the patentee or his legal representative can, within 18 months from the date on which the patent ceased to have effect, then they need to make an application in by submitting form number 15 for restoration of the patent. So if the controller is satisfied that the failure to pay the renewal fee and was like it was unintentional, and that there has been no doubt of delay, like no or any reasonable justification will be there because of their reason for not filing the application fee renewal fee within that time, then the patent will be restored. So, in another way, this is a manual procedure for filing the application. So, if we talked about a little bit brief about for the e-procedure for filing the application, then like we can say the procedure like of that completing the e-filing for the patent application by simply go and visit the Intellectual Property Office of India's the application website, government official website will be available. By applying over there, patent online, allowing the users or the browsers for to the users, which is showing you the interface around to complete the electronic application, which provide the associate attachments also and complete the necessary payment design. So here the procedure you need to follow for e-filing is acquiring class 3 digital signature, like either form number N, or which need to be code solution, or for example any other the attached property like information is required, you need to give that also. Or if it is a new user, then new user for the new user, applicants, agents, or attorney can complete online registration by providing digital signature details to get a user ID and password for using the e-filing system of Indian Patent Office that we IPO. And thirdly, we can say that secure the login into a system with create user ID and password, which can enable download the client software for preparing the patent application offline with required the documents and digitally signed it for uploading to again the IPO server. By filing this patent application offline or generate an XML file using the client software. So after creating this application, that XML file, like this file offline, digitally signed by this file, then it need to be uploaded again to the IPO server. So in that way also you can file the patent application in like online. And what we can say, and the after completion of the all the step by step, it will be shown to you, like shown in that digital interface you can see. And once you get successful, you can get the download the acknowledgement details, which will be displayed or generated in your screen only. Then print your acknowledgement and click on print. Like that you can obtain to keeping the acknowledgement receipt with you. So, after completing the procedure for obtaining a patent in India, that the both manual and in a digital way, now we are going to discuss about another most important area, that is the international patent search. Now, how we need to do the how we need to do the international patent search, right? So, An application for patent search, it is a basically a systematic process to identify the existing patent and the prior art, right? So across the multiple jurisdiction university, and which usually undertake to check the novelty, freedom to operate, or to study the technological landscapes. So for this process, it will be begin with the clarity and defining the object of the searches. So whether it is to support for a patent filing or access to information risk or gain the competitive intelligence. So once the purpose is set, the innovation should be described in detail and broken down into with its main component, functions, and features. So for the features and relevant synonyms, technical terms, then possible foreign equivalents should have to be listed to broaden the search vocabulary. Okay. After that, the next step involves to identifying the relevant patent classification. So especially the International Patent Classification, that is called IPC, and a Cooperative Patent Classification, that is called CPC. Okay. So these code groups the patents into specific technology areas and allow the retrieval of the relevant document, even when in the different technologies are also being used. So after this step, one must select the appropriate database, like widely used free platforms, including that VPOS. I'm sorry. So basically, the widely used platforms which are being provided to the WIPOs, like WIPO is stand here, World Intellectual Property Organization. Okay, so WIPO is providing a particular platform which is known as WIPO's Patent Scope. If you search on that website, like the address, then you can see the further process for it. And another one that you like European Patent Office, that is uh, efficient, will be the platform will be available, and also the Google Patent, then which is supplemented by the national databases such as USPTO, CNIPA, which is basically CNIPA, which is owned by China, and then Japan also having their own database that is known as PlatPat. Okay, and in India we have the IPO portal. Okay, so by using this multiple databases, which is ensure the comprehensive coverage for your national patent, international patent search. Then the other searches are then conducted by combining the keywords with Boolean which with the Boolean operators, okay, and by applying classification codes. So broad searches should be gradually refined by focusing on fields like title, then by abstract or claims, or by filtering the dates of the jurisdiction. Apart from that, the citation searching, it is also an easiest way. So examining patent cited by a citing a relevant document is also can be a useful technique. So it is explaining. So you can use that short tricks to get a quick result. So once this relevant patent are identified, their like uh, familiarities, or we can say the legal status, must be checked to determine if they are active, or they are expired, or they are withdrawn. So based on that also you can file your application. This is the area of scope for your to getting a chance to get the innovation, like any patented license which is about to be expired, or after the period has been over, nobody is claiming. Still, that areas also will be there. So, alongside patents, non-patent literature such as journals, standards, conference papers should be reviewed, as they may be also contribute to the prior art only. So, finally, all the findings should be systematically documented in a report which containing the objectives, database use, and also the search strategies, and the key results and conclusion. So this structured approach ensure a reliable and reproducible international patent search. Okay. Now we need to get to know about that if they are having any patent specification and claims, then what or how we need to deal with that. So in terms of patent specification, a patent specification basically is the most crucial document is filed at the time of the Indian Patent Office during the patent application only. So it contains the technical details of the invention. So and its scope and the legal boundaries of the protection. A grant of patent it is basically like a patent. It's to be granted only on the basis of the complete of the specification only. So it's a very very important and crucial document. So, if we talked about the various classifications of specification, which is has been differently mentioned in our Indian Patent Act 1970, then we can see Section 9 has talked about some provisional specification, which is talked about filed when the invention is not fully developed. Okay, then it's also being stated that provides an initial description and secures a priority date. Then that particular application need must be followed by the complete specification within the 12 months. Okay. Then another provision, if you can see, Section 9, subclause 3 and Section 10 of this Patent Act, which is talked about a full and detailed disclosure of innovation. Okay. That invention has been talked about. It must be enabled to a person skilled in that particular art. Then to carry that particular innovation or invention, then only it will be acceptable. So, mandatory requirements are being stated that firstly, they need to be prescribed the title of invention, field of invention, background of the invention, that is itself also known as the prior art, then detailed description with the example, and by it will be better if they represent it through the diagrams and all. Then after that, the best method of performing the invention, and later on the claims and abstracts. All the things need to be clarified through this patent specification. And in terms of the particular commercialization of patent, if you want to explain that, uh, we need to discuss according to same the Patent Act is being describing. Once a patent is granted, the patentee enjoy the exclusive right to make, use, sell, or license the invention for next 20 years. Okay, and this tenure is being mentioned as per Section 53 of our Indian Patent Act. So later on, we are going to if we are adding some more additional information here, that commercialization ensures that the patent are not just kept idle, but bring the economic benefit. Here, based on this ground only, it is said that once the patent has been granted by the patent office, okay, immediately within the 3 years itself, it is being important for the inventor who taking the license in his name for that particular invention. So they are bound to utilize such invention for commercial purposes. If it is not, then that will be can be returned, or then the registrar of the patent office can uh, uh, take back the license or seize the license until the useful person can be requesting to using it for a commercial purposes or the commercial benefit. It can be done. So it is being very important for the inventor that the whatever the patent, the whatever the invention is being patented, it need to be used in the economic benefit. And if we say that the modes of commercialize how it can be done, then it is being defined as according to the provisions of I think Section 68 68 to 69 of that our the same act, Patent Act, which is talked about the assignment. If the inventor by himself is not being capable enough to utilizing such patent for commercial purpose, then they can do one thing, that they can assign their patent to somebody else. Okay. So this assignment can be done. The patentee transferred the ownership of the patent partly or wholly. Both they can be done. Okay. Or it can be done by this assignment can be done. Obviously, it should be like in written format and registered with the patent office. Okay. I need to be get permission from the patent office also. Then, by providing the licensing, the patentee permits the others like others to use the patent in return for royalties. Okay, and how they will get these types of royalties are like voluntary by providing a voluntary license, like then exclusive license, by non-exclusive license or compulsory license. Okay, so, like voluntary license will be granted by the patentee through contract, and exclusive license will be provided only the license can use it. Okay, exclusive license means whoever will be the original owner, exclusive owner, only they can use it. And non-exclusive license means multiple licenses allowed it. So the multiple like they can work in a dimension different areas also for to make that same patent need to be commercialized. And the another one we are hearing that providing a licensing, that is a compulsory license, which is very important here. That is compulsory license, like the whole detail of the conception is mentioned. If you go through with section 84 of the Indian Patent Act, it will be giving the entire in detail, the grounds and the procedure will be there. Okay, I'll briefly define this thing. So here, this compulsory license can be granted by the controller after 3 years. That from the date the licensing of the patent license has been granted. So only on the ground, if the innovation is not available to the public at a reasonable price, not worked in India, or public requirements are not met. Okay. So in such circumstances, means if any person is get a patent license, okay, and after that that particular person is utilize this patent and they are being taking the monopoly in the market in the for the industry, and they they make the product of the invented product price, they selling the price in such a high level that it could not be able to reach, or it could not be like possible for a common person to get purchase it, to get it. Okay, so then it will be the depending upon the necessity of the goods, it will be the governments having the full authority to take over it. So in that circumstances also, the invention which is not available to the public at a reasonable price, then it can be taken. Or if that innovation, for example, some innovation can be done and registered within India, but they are not selling that particular product. In case of specifically look into in the pharmaceutical industry, these are things can be done that majorly done. So these issues we can see on that area, so that if some medicine or something they are being invented and later on they are not selling in India, they are producing it to the foreign in a higher rate or something, and it is become the basic necessity for Indian domain, and then also the government of India can seize the license and make it as a compulsory license and control the government of India. And whenever it is a public requirements are not met, then also it can be done. After that, the technology transfer, like sharing known how with the industries and the research organizations are done. Then by franchising and joint venture also they can commercialize the particular commercialization by combining the patent right with business models or wider commercialization purposes, or commercial exploration by the patentee by directly using the manufacturer, like by himself, the inventor, will be manufacturing the goods, marketing the goods, or servicing the delivery itself. So, because these things are also being clearly used by the uh, our statute has been clearly mentioned. So the government use the patent granted for certain conditions are being met, which is directly provided our statute under Section 47 itself. And compulsory licensing, which dealt with the balance between the monopoly rights and the public interest. So now we are going to discuss about a brief about the another major topic, that is the infringement of patents. So it is being very much crucial to know if you're already like if your exclusive rights has been violated by somebody else, then what are the remedies will be available, or if it is not, then what are the defense can be taken. Okay. So infringement of a patent consists of the unauthorized making, importing, use, offering for sale, or selling any patented invention within the India. So the remedies against the infringement of a patented innovation are available are firstly, it will be the interlocutory injunction. So a patent owner at the start of a trial can request for an interim injunction to the restrain the defendant from committing the acts accompanied like of until the full hearing of the action or further orders. So, permanent injunction is given based on the merit of the case at the end of the trial. And another way the remedy can be provided, that is the relief of damages. So, damages means here the injury has been happened based on that the cost of reward will be provided. So here the award of the reward of the damages focus on the losses sustained by the claimant. Okay. So a patent owner is entitled to relief of damages as compensation to the patentee and not punishment to infringer. Now, thirdly, the remedy is available in accord to the account of profit. Okay, account of profit. So, account of profit focuses on the profit made by the defendant without referring to the damages suffered by claimant at the hand of the defendant. And the purpose of account is to prevent the unjust enrichment of the defendant by the use of claimant's invention. The patent or the owner may also opt for the account of profit where he has to be proof use of invention and the amount of profit derived from such illegal uses only. So these major three things like are the only the civil remedies are available. Okay, where interlocutory application by relief of damages or by way of account of profit. These are only the three civil remedies are available for patent infringement. Now, if we say about what are the penalties are being they prescribed under our Indian Patent Act statute is being talked about. That is, firstly, if they are having contravention about any kind of like secrecy provisions relating to certain invention, which is directly being protected under Section 118 of the Indian Patent Act. So, if any person fails to comply with any direction given under the particular statute or makes the clause to be made an application in contravention of Section 39 of the said Act, which shall be punishable with imprisonment up to 2 years or with fine or both. So, imprisonment first contravention of the provisions clearly stated 2 year imprisonment and along with the fine. So, the another ground will be there in terms of penalty will be falsification of entries. Like falsification of entries, if can anybody can be done or any person makes, then the causes of false entry in any registry kept under this act, then the particular person shall be punishable with imprisonment for a term which can be extended to again 2 years or with fine or both can be given. Then on the ground of unauthorized claim of the patentee's rights, then like for example, if any person represents any article sold by him is patented in India or is the same subject of an application for the patent in India, be punishable with fine that may be extended up to 1 lakh rupees. And the use of the word patent, patented, patent applied for, patent pending, then patent registered. These key terms, if somebody using without the mentioning the name of the country from where it is being made, so means they are patented in India or patented applied for India. Okay. So if they are being misusing or producing any false document, then they will be need to pay that penalty. After that, if they are using any use of any word like patent office or something, the words need to be reasonably brief with his place, business, or something. If he will be not done that, then he will be punished with imprisonment for term, which may extend it to 6 months, or with fine or both. Then refusal for failure to supply the information. They are again will be ready to like they need to be like if they fail to furnish the information as required, then they will be punishable with fine, which may be up to 10 lakh rupees. Or if he furnish false information knowingly, then he shall be punishable with imprisonment that may extend to 6 months, or along with that 10 lakh rupees fine, or more than that at the court will decide. So later on, the another penalty will be there that practice by non-registered patent agents, whoever like if any non-registered patent agents practiced and applying for the patent on behalf of the inventor, then any person practicing as a patent agent without registering, they will be liable to be punished with the fine with 1 lakh rupees. In the first offense, they can paid around 1 lakh, and the repeated offense, uh, and it will be subsequently they can be paid up to 5 lakh rupees. And lastly, the penalties will be dealt with there, which deals with offenses by the companies. Okay. So when the offenses is committed by any company, as well as every person in charge of and reasonable for the company for the conduct of his business, at the time of the commission of the offense, will be deemed to be guilty and will be liable to be proceed against the punishment. So, provided that nothing contained in this subsection shall be rendered, or any person will be liable to any punishment. So, if he proved that the offense was committed without his knowledge, or that exercise all due diligence to prevent the commission of such offense. Okay. So, if we talked about that um, patent opposition under the what will be the patent opposition can be raised like under the patent act provision will be there, then we can say there only we having only two mechanism to challenge the grant of patent in order to like patent frivolous or non-novel or unethical like invention from being granted exclusive rights. So the opposition system the opposition system act as a safeguard to ensure the patent only which is genuinely new or useful innovations. There are basically two types of opposition under this act. First is pre-grant opposition, and another one will be post-grant opposition. So the pre-grant opposition can be filed by any person, including any individual company or even NGOs also can file an opposition after the patent application has been published, but before the grant of the patent, only on the ground of wrongful obtained information, prior publication, invention was claimed under earlier field. Okay, the patent lack of inventive steps. These are the general grounds will be there. Then the simplest procedure for by filing an application before the controller of the patent, and they will be examine the application and consider the submission and everything will be done. So if that opposition is successful, then the patent is not granted. And we talked about another aspects of post-grant opposition that can be done by that any interested person may file an opposition within 12 months from the date of the publication of the grant of patent only on the ground. based on wrongful obtained invention, lack of novelty inventive state, subject matter is not specifically prescribed, insufficient disclosure of the specification, and failure to disclose the information about corresponding foreign application or prior publication. These are the things at the basic ground, like anticipatory, like anticipation only just by the traditional knowledge, and all these are the basic grounds will be there. If the opposition succeed, then again the patent may not be like the patent may be revoked or amended. Okay. So, in short, we can say the patent opposition under the Patent Act, it is a crucial mechanism ensuring only the like valid, novel, and useful invention are granted like patent rights. So, pre-grant proposition act as a preventive tool, while the post-grant opposition serves as a corrective tool. So, together they create a strong check and balances system in Indian patent regime. So now, if we in short talked about that the grounds of defense, what are available under the Indian Patent Act, which is basically covering the three major areas. First is a invalidity of the patent itself, and by like all the revocation of the grounds under Section 64, or secondly, permitted use, like for the if it is that registered patent can be used for the research purposes or parallel importation for any educational purposes or something, then it can be granted. Or non-infringement arguments like product process does not fall under the claims, exhaustion, or the licenses. So the all the grounds available for revocations will be available under 107, under section 107 of this particular Indian Patent Act. You can briefly go and look after that provisions. So every ground on which patent may be revoked is also available as a defense as well. So the defendant may argue that the patent itself is invalid. Okay. So the major ground for revocation under Section 64 is talked about to be taken as a defense, including lack of novelty, lack of inventive states, non-patentability subject matter, wrongful obtaining, insufficient disclosure, failure to disclose the foreign application, failure to disclose the source of geographical origin of the biological material, anticipation by traditional knowledge, patent granted on misrepresentation by fraud, or patent already claimed by the another valid person. Now, grounds for defense for non-infringement or permitted. It will be providing that a bowler provision is being mentioned under Section 107 of Indian Patent Act, which stating that using a patented invention solely for the research or development or for obtaining regulatory approval. Okay, for example, like clinical trials, testing for drug approval. So, in such circumstances, it is not amount of infringement. Or parallel importation, if we can say, that is important patented product like from a person duly authorized under the law to produce and sell it, then it not amount to be infringement. Okay. And the other general defenses are available like non-infringement, defendant product does not fall within the patent claim, or general things like public interest or compulsory licensing, then cost of license, defendant, if they are paid for it. Okay, the assignee, if they paid the royalty to the real inventor, then also it won't be count as a patent infringement. Now, here we need to understood a one basic conception in short about the if they are having any infringement, then how the procedure will going. So to deal with those claims, we having the intellectual property appellate board (IPAB). So this is the IPAB is a statutory authority made by a statutes which is talked about for to deal with the all kind of issues, okay, regarding the infringement and all other claims will be there. So it was set up by the chairman under Section 83 of the Trademark Act 1999, but it was made operational for trademark, geographical indication, And however, it will be also applicable for the other IPs as well. So the Ministry of Commerce and Industry and the provisions for the Patent Amendment Act 2002 and the Patent Amendment Act 2005 relating the like intellectual property appellate boards have been brought into force. So thus the appeals, like whenever they are filing the complaints before the registered office or something, if they are not satisfied with that, so they can go for the appeal. They can bending before the various high courts or which will stand for transfer to the IPAB. Okay, so just this IPAB is to be reviewed, like the alternatives of that particular high court only. So likewise, like the fresh rectification application under this Patent Act will have to be filed before the IPAB. So the importance of IPAB is basically or we can say a little bit about that Intellectual Property Appellate Board. Um, that will be working. It's a creation mark for a significant step in ensuring a more efficient technical or expert-driven adjudication process in India, involving the IPR regime only. If we said about the importance of IPAB, the specialized experts they having like traditional court whatever we having same as like IPAB consists of both the judicial and technical members ensuring the highly technical patent issues were decided with the domain of knowledge. So it's a quasi judicial body actually, so made for the speedy resolution. So IPAB aim to reduce the delays of the IP dispute settlement and offering the faster disposal compared to the regular courts. And another important is it reduces the burden on the courts. Okay, and promoting the innovation and investment is another important features of this. So here the major primary focus is that the efficient dispute resolution boosts the investor confidence. Thereby, they will be encouraging the research and development and innovation. Or we can say the most major important of IPAB is this body is balancing the public interest plus monopoly rights. So IPAB decisions often maintain a balance between like protecting the patent rights and safeguarding the public access. So particularly in the pharmaceutical sector, Novartis, like Novartis versus Union of India's case will be the major landmark judgment which is come out through this IPAB only. So it is a case where IPAB's role in pre-litigation process was very, very crucial. So, the this bodies intellectual this board having this the major powers they having such as like the same as like appellate jurisdiction they have include like regarding the hearing of appeals, decisions or orders same as like the controller of patent under the Patent Act is prescribed. Or here is an option that appeals lay to the directly IPAB instead of going to High Court. Like after 2002 only amendment, it is being specified. You have an option that you can approach directly to the High Court or alternatively IPAB. Okay. So at a time, you can approach only once. So if you are going to approach IPAB, you are not allowed to approach the High Court. Another power will be giving to the this board is revocation of patent. So IPAB could entertain petition for revocation of patent under Section 64 of the Patent Act also, and it could also handle the counter claims of revocation which made the infringement proceeding. After that, the rectification of the registered, it's also IPAB could rectify any entry which is the patent registered or concerning the errors or illegal registration, whether it will be there or not. Or we can say that it having the power of transferring the pending cases. So if they're having any appeal or revocation petition pending before the High Court, were transferred to IPAB after its establishment. The most major important judicial uh, power they having, it is quasi judicial power. That is, IPAB had powers to being act as like a civil court, so they can summoning the witnesses and receiving the evidence or issuing the commissions, etc. Same as like our procedural laws we having. So their functions are like hearing the appeals and resolving the disputes and providing the justice to all. So in that way, the IPAB plays a very crucial role for strengthening India's IPR regime by providing a specialized form of like patent related disputes. So here we are completed today's section. If anyone having any question or query or doubt, anything, you can type in a message in the chat box or you can ask your query directly.